Up next, we have one of the Owners Corporation industry's most respected and genuine lawyers, Mr. Mark Lipshutz of CLP Lawyers, to take us through the upcoming changes to the Owners Corporations Act and how they may impact you as owners corporations. CLP Lawyers have extensive expertise in owners corporation law, understanding the complexities and nuances involved in both vertical communities and large suburban estates. So thank you, Mark.
Thank you very much, Gregor. Firstly, I want to say thank you very much for having me again tonight. It's always the highlight of the year, and I also want to particularly, I do want to particularly thank the Knight for the timing of tonight's event, because as a Melbourne supporter, I don't usually have anything to look forward to in grand final week, so this is a pleasant surprise for me. I also apologise in advance. The topic tonight is going to be talking about the changes to the Owners Corporation legislation, which can be quite a dry topic, but a very important one nonetheless. The changes are quite lengthy, and I could probably speak about it for 20 hours instead of 20 minutes, so I don't think I'm going to be able to cover absolutely everything, but I'll do my best to cover as much as possible and then hone in on some of the key areas that are going to affect the people in this room. The bill was introduced into Parliament about 2 weeks ago, actually, and the second reading speech was done. It'll be voted on, we don't know exactly when, but shortly, and the changes, assuming they pass, which we expect them to, will come into effect at the latest on the 1st of January 2021. It may well be earlier, but we don't yet have any more updated information on that. The review is absolutely long overdue. This Act has been in its current form since 2006, so 13 years in legislation is quite a long time. Unfortunately, as you'll find out throughout this presentation, I don't necessarily think they've done the best job possible, and I think the likely outcome of the changes is that they won't fix what a lot of the problems are at the moment. In fact, they'll probably create more problems. And I apologise for saying that. I wish I didn't have to. The purpose of the changes is to rationalise the regulation of owners corporations, to improve the quality of managers and enhance protection for owners corporations, expand and improve developers' duties, which is clearly something they should be doing, and improve governance and financial administration of owners corporations. I'm going to touch on those aspects just very briefly. So in terms of rationalising the regulation of owners corporations, they're going to be introducing a new 5-tiered owners corporation system, which sounds very complex and probably doesn't achieve a lot, but I will speak about that shortly in detail. There'll be an increase in public indemnity insurance coverage from $10 million for any one claim to $20 million, and having just heard from Michael, it's possible that may well lead to an increase in your insurance premiums. There will be a requirement to properly fund the maintenance fund to cover maintenance plan expenses, which is a good thing, and the intention behind that is so that owners who buy into an owners corporation don't, in their first month suddenly get a huge bill or huge levy to cover a maintenance item that should have been covered previously by the previous owner. And they're going to be seeking to correct anomalies in the Act, although it's not clear which ones, and streamline decision-making by removing the requirement for the common seal, which is long overdue, and that's a very positive change. What I will say is it will still require 2 lot owners to sign any document. So the only thing that changes is you won't have to actually affix the seal itself. In terms of improving the quality of owners corporation managers, and I'll say you probably can't do that in this case, but I'll charge you later. They're going to strengthen the regulation of owners corporation managers. They're going to prohibit certain contractual terms in the management contracts, which is an absolutely positive thing, I believe, because it will hopefully do away with some of the rogue operators. It'll be giving increased powers to VCAT to rule about the validity of clauses in management contracts, and will increase the duties of owners corporation managers, and I will speak about that in more detail, but I think that's actually a bad thing. They'll be prohibiting the pooling of funds of multiple owners corporations into one account, which I assume isn't done anyway by most owners corporations, so managers, so that's again really targeted at the rogue operators. In terms of the developers, the obligations and prohibitions on developers will be expanded out to 10 years from it's currently 5. That's in line with New South Wales. That's a positive step. The initial setting out of lot liability and entitlements will now have to be put in a report by a surveyor when a new development is done and attached to the plan itself. And that's really to avoid situations where, the developer, for example, might give themselves the penthouse with a lot liability of 1 and everyone else gets 100. This will now hopefully stop that from happening. To improve the governance and financial administration and internal relations, managers will be given powers to pass interim resolutions in certain circumstances. There'll be an increase in the powers to access private lots, an increase in the duties of committee members, a reduction in the maximum size of committees, and a change to the use of proxies. There'll also be changes to the dispute resolution requirements. It'll make it easier to pass interim special resolutions. There'll be an increased ability to recover costs in VCAT matters, which is the number one positive in my view. And there'll be greater power to make rules. And lastly, there'll also be a grant of power to owners' corporations to dispose of abandoned goods. And I think you're all probably thinking what I was thinking when I read that. And I'll say it doesn't include abandoned vehicles, which is a really disappointing element. The 5-tiered owners' corporation system is designed to ensure that the degree of regulation is commensurate with the essentially size of occupiable lots and owners' corporations. The term occupiable lots is a new term in the legislation. What it essentially means is a lot that is used for residential or business purposes. It doesn't include car parks and storage cages, so they won't be included. To calculate it, so Tier 1 will be more than 100 occupiable lots, Tier 2 is 51 to 100, Tier 3 is 10 to 50, Tier 4 3 to 9, and Tier 5 is a 2-lot subdivision. It sounds really fancy saying we have a 5-tier system now. The reality is we already have a 3-tier system. As it currently stands, you have prescribed owners' corporations, normal owners' corporations, and 2-lot subdivisions. So all they've done is kind of expanded out that middle bracket into tiers 2, 3, and 4. But you'll see as I go through it, there isn't a lot of change that's going to be applicable to you. And I know Gavin's going to speak about the accounting changes and the auditing changes afterwards, so I'm not going to touch on that. In terms of Tier 1, which I assume there'll be quite a lot of you in this room fall within that category, it's the largest and most heavily regulated tier. They must have an annual audit commissioned by an independent auditor, must prepare an improved maintenance plan within 12 months, and must appoint an owners' corporation manager, although that can be done away with by special resolution, although I'll say, if you have over 100 occupiable lots and you don't want a manager, you are crazy. Tier 2 owners' corporations must have an annual audit as well. They must also prepare a maintenance plan. They are not required to have an owners' corporation manager, although again, you would think in most cases with over 50 lots, you are going to have one. So there's not a great deal of difference there. I've categorised tiers 3, 4 and 5 together. There's no requirement for an annual financial audit, there's no requirement to prepare and approve a maintenance plan, and there's no requirement to have a manager. The outcome that we're told will happen is that the tiered system provides greater protection to owners' corporations in tiers 1 and 2 through greater regulation and more accountability, while allowing the smaller tiers or the lower tiers to have greater flexibility while still being legally compliant. In reality, these changes are overly complex in my opinion. There's no real need for this change, and it doesn't really make any difference the way we're currently practicing. Maybe from an accounting point of view, but that might be about it. When I break down the changes as a lawyer, I don't go through the categories they went through. I look at it in 5 different ways. I say there are changes that affect managers, changes that affect developers, committees, VCAT, and then miscellaneous, because I couldn't think of anything else for the last category. The managers component is probably the most heavily, the greatest change comes to their aspect of it. And a lot of those changes are really good and some of them are really bad. And I'll take you through them. So there's going to be significant changes to the contracts of appointment. Rollover clauses for a full year. So at the moment, what a lot of contracts do say is that if you don't terminate by the end of the contract, it rolls over for another year. I'm seeing 5 from some people there. That's going to be outlawed. It can roll over, but if it does roll over, you'll be able to terminate it on 1 month's notice. The maximum term of management contracts will now be 3 years, which I think is a really positive change as well. And the decision to terminate a manager cannot be restricted to a special resolution or a resolution at a general meeting, which is essentially a way of saying that the committee will have the power to terminate the manager and also to appoint a manager. So it'll make it more fluid and flexible and easier to do it. There'll also be terms there that, this is a funny one, you cannot restrict the ability of an owner's corporation to refuse consent to the assignment of a management contract other than a requirement that it not be unreasonably withheld. That sounds really good. The problem is there's a note at the end of that legislation which says, essentially, it will be deemed to be unreasonably withheld if the assignment is to a manager who's a member of an industry body. So it doesn't really achieve much, in my opinion. It means that, I know Gregor's a member of SCA and on the board, it means that SCA, as the industry body, will really have to take responsibility for weeding out the bad managers, and the government's and legislation is really shifting the onus onto them to now police that. And I don't think that's so hopefully that we're going to see some more hardline stances from the SCA. There are a lot of new duties given to owners corporation managers. Now, the one that's probably going to cause the most controversy is a duty to take reasonable steps to ensure that any goods or services procured by the manager on behalf of the owners corporation are procured at competitive prices and on competitive terms. That, on the face of it, seems like a really positive duty to put on the manager. In practice, the way I see it playing out is that it's going to cause a lot more litigation. It is a really vague term. What is, competitive price? What is a competitive term? What are reasonable steps? That's not defined anywhere. And, I'll do a quick show of hands. How many people in this room, within your owner's corporation, can think of one person who's somewhat difficult? There you go. What this is going to lead to, unfortunately for managers, and it's also unfortunate for owners corporations because of the flow-on effect, is I'm expecting to see, as a lawyer at least, I'm expecting to see a lot of litigation happening as a result of this, because what will probably happen is the knight will get a call saying we've got an emergency plumbing problem. They will send someone out, they'll get 3 quotes, do what they have to do, and it'll cost $5,000. The difficult person in the owners corporation will say, I've got a mate who could have done it for $500. That's unreasonable. And they will then seek to take proceedings against the owners corporation manager. And the owners corporation manager, of course, will have an indemnity in their contract of appointment with you as owners corporations, which means you will end up wearing those legal costs. So I just don't see why that has to be included as a duty when the owners corporation manager already has a duty to act in good faith. So it's totally unnecessary. There'll also be a duty not to exert pressure on any member to influence the outcome of a vote or an election. Again, the same thing will probably happen here. Now, owners corporation managers, when they're in your meetings, will have to be really, really careful what they say. Because if they say, for example, we've got a building with significant cladding issues that's in the middle of litigation, and we've got a really active committee, and they say, look, we think it'd be good for the owners corporation to have continuity, that can then be interpreted as the manager influencing the vote. And of course, someone who doesn't get on the committee will then probably go to VCAT against the manager. So I'm expecting to see a flood of litigation, I'm sorry to the knight, a flood of litigation happening against managers, certainly at the early stages until VCAT comes down pretty hard on that. And VCAT will find against those applications and they'll dismiss them, but it's going to take time for that to filter through with precedents. There'll also be an obligation to disclose any commissions that the owners corporation manager receives. That's a positive, I don't have any issue with that. The only problem with that one is the disclosure requirement goes to the chairperson of the owners corporation. It's not a disclosure requirement at the AGM, for example. So unless the chairperson then seeks to pass that on through his report, the owners corporation members won't know about it. New powers will be given to managers to pass interim resolutions where no lot owner is represented at a general meeting. I'm assuming that won't be the case for you guys, because obviously you're interested owners corporation members, you'll have people attending, but for smaller ones where no one turns up, that's a really good thing. The exceptions are they can't obviously pass resolutions about their appointment or their contract, or anything that involves an amount greater than 10% of the budget. I think that's a positive change. When it comes to developers, new plans, as I discussed before, will have to set out the basis for lot liability and entitlement. That's a really positive change as well. Developers cannot appoint themselves or an associate to be the owners corporation manager. That's a fantastic change. The only problem with it is if you look at the definition of associate, it leaves open so many loopholes that developers are going to be able to get around that, in my view. And they'll be able to have related companies in certain ways that will still be able to do what they're doing now. The one restriction they'll have on themselves will be they can't appoint the manager for more than 3 years. So at least that is a positive. Developers will not be able to vote on resolutions in relation to building defects. I find that to be a really curious change, because at the moment we don't sue developers in Victoria for building defects, so I don't know why it would impact upon them. I understand if it was the builder. The problem with this, and it hasn't been explained in the legislation, the changes, is what the impact will actually be on owners' corporations who are now trying to sue builders, because you need to pass a special resolution to be able to sue the builder. If the developer holds a significant amount of the lot entitlement and they can't vote, the question is going to be, how do we actually get around that to pass the resolution? So they might have created a rod for their own back there, I think, with that legislation. The developers will be prohibited from proposing unreasonable or unsustainable annual budgets. They will be prohibited from designating what would ordinarily be common property to be private property. That's a really good thing, because what I'm seeing a lot of at the moment, maybe it's a rush to do it before the changes come in, is that developers are allocating the visitor car parking spaces to be their personal property and then leasing it out to the owners' corporation on long-term leases. That's now going to be prohibited. So you won't be able to do that anymore. And obviously they won't be able to receive any kickbacks from owners' corporation managers, although I don't know how that's going to be properly policed, or anyone's going to notice that. When it comes to the committee, and this is what will probably interest a lot of you, there seems to be a lot of changes and they don't really go very far. The maximum size of committees is going to be limited to 7 members. It's currently 12, it's going to go down to 7, of course, unless you pass an ordinary resolution to put it back up to 12, or any number in between. So, I mean, if more than 7 people stand, it's not going to be very hard for people to say, okay, we'll have more than that. So I don't think it's going to be a practical change at all, other than making it open again to more interpretation and more dispute. The requirement to have a committee is presently you must have 13 or more lots. That's going to be reduced to 10 or more lots, which will mean that essentially now tiers 1, 2 and 3 will have to have committees. I don't think that's going to have too much of an impact. Committee members may only give a proxy to another committee member for committee meetings. This is a really positive change in my view, because what we're seeing at the moment is people stand for committee, they then never turn up, and they give their proxy to someone else to represent them who was never voted in by the members. And that person becomes a default committee member, even though the members might not want them to. So this makes more sense, because now what will happen is if you don't turn up to your committee meeting, you can give a proxy, but it's got to be to someone who's already been elected onto the committee. That's a really positive step. Committee members now have a duty to act in the owners' corporation's best interest. I don't know why that needs to be spelt out again. There is already a duty to act honestly and in good faith. So it's a bit of tautology there, unfortunately. When it comes to VCAT, VCAT will have greater powers to deal with owners' corporation disputes, to deal with abandoned goods and validity of management contracts. There'll be an increase in the penalty for breach of rules from $250 to $1,100. Again, that's really positive. The problem is, I don't think I've ever seen VCAT hand out a penalty of $250, and I don't think they're going to hand out a penalty of $1,100. I don't think in practice VCAT likes to do that. There'll be a new power to grant an order requiring a lot owner to pay to the owners' corporation reasonable costs incurred by the owners' corporation in recovering an unpaid amount from the lot owner other than the legal costs. That is the best change probably in this legislation, because what that means is, and what happens all the time, we go to VCAT to try and recover your fees. Someone doesn't pay, the knight will send out a notice to them, they will incur costs in doing that, and so will the owners' corporation, and we will go to VCAT and the member will say, I'm sorry, you can't get that back. So hopefully now we'll be able to get those amounts back, which will mean you will be less out of pocket, and it will act as a greater deterrent to owners to not pay their fees. Because now if they don't pay them now, there's no real penalty other than a little bit of interest. This will now hopefully see greater compliance with paying fees. An owners' corporation will be able to commence legal proceedings for any matter under $100,000 by passing an ordinary resolution instead of a special resolution. That in itself is a good thing. The problem with it, and where it doesn't go far enough, is it won't allow owners' corporations to commence bankruptcy proceedings. So if, for example, we go for a fee recovery, and we can do that because it's under $100,000, we get the order from VCAT, and then the owner doesn't pay, and we want to bankrupt them to enforce it, we can't do that because it only applies to matters in VCAT or the Magistrates Court, or the Magistrates Court equivalent in another state. And of course you can't commence bankruptcy proceedings in the Magistrates Court. So you will still have to get a special resolution to then take the next step. Also, when it comes to building defects, I don't know about you guys, but it's pretty rare you have a case for under $100,000 these days. So I'm not sure how big an impact that's going to have practically. And in fact, what they have done, it seems, is they seem to have removed the ability to take legal action for a breach of rules by passing an ordinary resolution. So that there's now an argument that may now require a special resolution. So this may actually be a negative change, unfortunately. When it comes to the miscellaneous section, there is the power to dispose of abandoned goods. The problem with this is it doesn't deal with vehicles, and also you have to know the owner of the goods because you have to serve them with a notice. So if you don't know who it is, you actually still can't do anything. So I don't know about you, people that abandon goods generally don't tell you they're doing it. Occupiers will now be liable for breaches of the rules by their guests. That's a really good thing because what it avoids is the argument being put up by tenants or owners saying, I didn't cause that damage, it was my mate who came over. So the exception to that is if you have given your mate a copy of the rules, then you will not be liable. So I guess for all of you guys, anyone you have over now, just pin the rules to your fridge and tell them to sign it before they walk in. You can now also make rules about the drifting of tobacco smoke. Interestingly, only tobacco smoke, no other smoke. I don't know why they would specify, but they did. And that's, again, you can now prohibit that. And then theoretically you can go to VK if there's a breach and get an $1,100 fine. Proxies is one of the biggest changes as well. One person now cannot vote as a proxy at a meeting on behalf of an owners corporation of more than one lot if there are 20 or less occupiable lots, or 5% of the lot owners if there are more than 20 occupiable lots. So if we assume that most people in this room are in an owners corporation of more than 20 occupiable lots, you now can't hold a proxy for more than 5% of lot owners. So that could create problems with getting a quorum. For managers, again, it might create more problems, but it also is designed to avoid proxy farming. I don't particularly love that change because I think if someone gives a proxy, they should have the choice to who they want to give it to, and if they want to give it to the same person as everyone else, then that's their right. But that's now being taken away. The requirement for ballots to be left open for 14 days has been tweaked a little bit. It can now be reduced in the case of urgent matters. Clearly, they don't define what an urgent matter is, which again will lead to more litigation as we have arguments about that. And interim special resolutions can now be passed if there is a quorum and there is less than 50% of total lots in favour, but none against. This is my favourite change because of how redundant it is. So, an interim special resolution at present is you must have at least 50% of the total lots vote in favour of it and no more than 25% against. Now, clearly, to have a quorum, you need to have 50% there. So if you don't have a quorum, this doesn't apply. If you do have a quorum and no one votes against it, it would have already passed as an interim special resolution. So it actually makes no difference. The top five, I'm sorry to be so cynical, the top 5 takeaways for you guys tonight, hopefully, will be the requirement to have a committee now applies to owners corporations with 10 or more lots instead of 10 or more occupiable lots instead of 13 or more. Committees can now have a maximum of 7 members, but that can be increased to 12. So you have to remember at your AGMs that if you do have more than 7 people standing, you should first pass a resolution to increase that number. Otherwise, it'll be challenged later. Special rules will unfortunately need to be updated for all owners corporations to include things about smoking, for example, works to private property and a few other things that they're now allowing. Proxies will need to be really carefully monitored to ensure that people don't hold too many, and that's also going to be an absolute nightmare at a meeting, trying to work out if you've got too many or not for the manager. And maintenance plans will need to be prepared and adopted for Tiers 1 and 2 owners corporations. Those are the most significant changes. There are a few others, but as you can see, I don't think there's going to be a huge change to the way that owners corporations practically run. Thank you.
Thank you very much, Mark.